Okay.
Hi, my name is Dennis Collard. I'm a founding member of the firm Collard Shockley. We practice family law here in Atlanta. Today we're talking about alimony. Starting basically with the purpose of alimony, both the statute and the case law applicable to alimony creates kind of an overarching umbrella test, which is that alimony is based on the needs of the spouse requesting alimony and the ability of the other spouse to pay. You'll hear the judges talking about it in those terms, mediators, lawyers. You'll hear clients talking about it in those terms. When people come in for initial consultations and you want to give them the one-sentence description of alimony, then needs of the spouse requesting alimony and the ability of the other spouse to pay is the main test, although there are factors that we'll talk about here in just a minute. Conduct of the parties is relevant as to the issue of whether or not the court grants alimony, but alimony, the amount of alimony cannot be based on conduct. So OCGA 1961 and Odom versus Odom state that the court can consider conduct as to the decision as to whether to award alimony or not award alimony. Then the amount of alimony cannot be based on conduct, though. It is based on need and the other factors that we're about to discuss, which are found at OCGA 19-6-5. So the statutory factors to be employed by the court in determining alimony are the standard of living established during the marriage. This can be very difficult to prove because it can be subjective. There are issues that many clients raise as to the continued wanting to maintain the standard of living that was established during the marriage, and the potential payor of alimony typically will dispute that, and most judges will say that there's going to be some change in the standard of living. But discussing the standard of living can be helpful, especially in a long marriage, and it is a statutory element. The duration of the marriage, this of course is an easy factor to prove. The longer the marriage, the more likely there will be alimony. The age and the physical and emotional condition of both parties is the third element. The financial resources of each party. This is an interesting one because this can also be somewhat speculative. It can help to have a financial expert talk about how one party is going to continue to work and make a certain income, while the other party is going to be living essentially on alimony, and sort of project that out into the future. So that is helpful. Where applicable, the time necessary for either party to acquire sufficient education or training to enable him or her to find appropriate employment. If you have parties who are divorcing after a short period, or both are professionals, perhaps one has been out of the workplace for a few years but could re-enter the workplace relatively quickly, or if you have an extreme situation where someone has never worked at all and perhaps re-entering the workforce in a meaningful way may not even be possible based on their age, then that element is very important. The contribution of each party to the marriage, including but not limited to services rendered in homemaking, childcare, education, and career building. It's a very important element because in alimony cases we often have someone who has stayed home as a homemaker, a stay-at-home mom or a stay-at-home dad, and here we have in the statute itself the legislature saying that is specifically very, very important. Career building of the other party, if you have someone who's doing particularly well after a long marriage, then most of us would argue to the court that would not be possible without the other parent or the other party supporting the person who went out and built a career. Another element is the condition of the parties, including the separate estate, earning capacity, and fixed liabilities of the parties. Separate estate it is a big one. We have people who are requesting alimony even though they perhaps received an inheritance. And the argument there often is, well, I should not have to invade my inheritance to support myself after the marriage. That can be a tough sell. It's obviously relevant. Earning capacity, that's similar to the previous element that talks about re-entering the workforce. And fixed liabilities of the parties. That is something that will largely be determined by the outcome of the divorce, what the liabilities are going to be. And then the eighth statutory element, which is a catch-all, is other relevant factors as the court deems equitable and proper. Well, this makes essentially anything relevant as to alimony, except, again, the amount of alimony cannot be based on the conduct of the parties, cannot be used to punish. But it essentially opens the door to anything that would have to do with the financial need or ability to pay. There are generally 3 kinds of alimony in Georgia. 2 are rarely awarded, and 1 is very commonly awarded. The first is a lump sum alimony. Lump sum alimony we usually only see by agreement, and it's because somehow it makes sense in the divorce. Generally, lump sum alimony is not tax deductible. We'll talk more about that later soon. All alimony will not be taxed and will not be tax deductible. But lump sum alimony is basically as it sounds. It can be a lump sum of cash. It can be lump sums of cash. In other words, so much this year, in another year, some other lump sum, and in a third year. In other words, you can spread them out. You can have lump sums paid in installments. But essentially, what the statute says the jury instructions would instruct a jury that the jury can make a lump sum cash award to be paid out of the estate or assets of the other spouse. It can be paid in one payment or for a specific period of time as the jury may determine. And anytime I say jury, of course, that means judge as well if you're having a bench trial, which most cases will go to a bench trial and not a jury. Another type of alimony is alimony in kind, which, as we are told to instruct the jury, or as the judge is supposed to consider, is an award of designated property, including personal property and real estate, or an award of a designated interest in real or personal property. Alimony in kind is something we see very rarely, but it's something that people are often worried about. In theory, a court can award a house, for example, as alimony. Again, we don't see it very often, but it is possible. The most common kind of alimony in Georgia is periodic alimony payments. Periodic alimony payments are to be paid in the future, for example, weekly, monthly, or quarterly. Typically, they're monthly. And for agreements entered up until the end of this month, this was sort of the most typical kind of alimony to be paid monthly. It can be modified later. It is taxable to the recipient, tax deductible by the payor. This is sort of the type of alimony that most people out in the public or most potential clients who come to see you have in their mind as being alimony. Interestingly, and we don't often cite this in court, but it's something that is important to remember, that there is case law that allows you to remind the judge or to instruct the jury that alimony is not a substitute for division of property. Alimony and equitable division of property are not the same thing, and the jury or the judge are not to interchange them. Alimony, again, is based on the factors, it's based on need, ability to pay. Equitable division can, for example, be based on conduct of the parties. There are different tax ramifications, there are different tests. So you can remind the court or instruct the jury that these are not the same thing, and there's case law that supports that. Technically, attorney's fees are alimony in Georgia, but as we know as family law practitioners, there are specific statutes that deal with attorney's fees in divorces, and we often will treat attorney's fees as separate from temporary alimony. There is a relatively recent case law that can be helpful when you're drafting or when you're dealing with a prenuptial agreement, rather, that says that even though a prenuptial agreement might purport to waive temporary attorney's fees, that would be against public policy, and temporary attorney's fees are still available. That's an interesting element of attorney's fees, alimony, and prenuptial agreements. So once you have an award of alimony, you have a final judgment of the court, and alimony is in progress, it is modifiable unless that modifiability is waived. If you waive modifiability, you have to be very careful about the language that you use. There's the well-known case Varn versus Varn. It's very useful to pull that and look at that as being a guide as to your waiver of modifiability language. But basically, OCGA 19-6-19 provides that alimony will be subject to division after a showing of a change in the income and financial status of either former spouse. Interesting language here, change in the income and financial status of either former spouse. A lot of people will seek a change in alimony or modification of alimony based on income or financial status. Technically, the statute says income and financial status, so that's a good pointer as far as making your arguments to the judge. Generally, alimony is only modifiable every 2 years, but a party does not have to wait 2 years from the original final judgment to make their first request for modification of alimony. Alimony is also modifiable under the so-called live-in lover law, which is OCGA 19-6-19B. This deals with the concept of a meretricious relationship. There are a lot of misconceptions about this live-in lover law. Alimony does not automatically terminate upon a showing of a party's entry into a meretricious relationship. That just renders alimony modifiable. The court does not have to modify alimony, but the court can modify alimony all the way to 0. Many practitioners will include in the settlement agreement a term which states that upon a finding of entry into a meretricious relationship, then alimony will terminate, but that is a matter of a settlement agreement. The default is that it is only modifiable. Generally, alimony is modifiable if you have cohabitation and you either have a sexual relationship or you have a sharing of expenses. So that's generally the test. First, they're living together, cohabiting, meaning dwelling together continuously and openly in a meretricious relationship with another person, regardless of the sex of the other person. So this covers heterosexual and homosexual relationships. And again, once that is met, if there is a sexual relationship or the sharing of expenses, then you can potentially, the payor can potentially seek a modification of alimony. So that is the live-in lover law, the so-called live-in lover law. Now, regarding recent changes in the law, the Tax Cuts and Jobs Act of 2017 was signed into law by President Trump on December 22nd, 2017. And essentially, alimony paid to an ex-spouse will no longer be deductible by the payor, and alimony payments will no longer be included in the recipient's gross income as to any agreements that are entered after December 31st, 2018. So agreements that are entered during 2018, which as of the date that I'm recording this, we're still in 2018, you can set up tax-deductible alimony. Agreements January 1st, 2019 and later, alimony will not be tax-deductible and will not be taxed as income to the payee. So essentially, the practice point there would be to gross up the alimony amount because you want to make sure that the recipient is receiving what's expected and make sure your payor understands that there's not going to be a deduction. This also raises an interesting point as to prenuptial agreements. If you enter a prenuptial agreement today, that would be in 2018, but the divorce, if there is one, would likely occur January 1st, 2019 or later. So a good practice point would be for any prenuptial agreements that are entered from here forward, even if they're entered in 2018, don't try to declare that the alimony will be tax deductible because it likely will not be, because the test will probably be as of when the divorce occurs, not as of when the prenuptial agreement is entered. Now, if you are going to attempt to make alimony tax deductible because you're entering a settlement agreement or you're seeking an order during 2018, the elements per the Internal Revenue Code are that the spouses don't file a joint return together, the payment is in cash. That can be a problem. A lot of people want to claim that some other type of alimony payment is tax deductible. The payments must be in cash. The payments must be made pursuant to a divorce or separation agreement. The separation agreement can't say that the payment is something other than alimony. and the spouses cannot be members of the same household when the payment is made. So even if alimony commences and the parties are still living under the same roof, which is rare, but some parties try to do it, for example, until the house sells, that would not be tax deductible. And alimony must terminate upon the death of the recipient spouse. It doesn't have to terminate upon remarriage, but it must terminate on the death of the recipient spouse. All of that to say, this only applies again to agreements that are entered by December 31st, 2018, but it's important to keep all of this in mind because all of the previous agreements that we might be dealing with on a post-judgment basis, so any agreements made years and years before 2018, that are coming back before the court as to some kind of enforcement issue, that tax-deductible alimony is still going to be treated as being tax-deductible. So keep these elements in mind if you have a deductibility issue that comes up later. Also, I'll always be mindful of the alimony recapture issue. It's always good to just go online, and if you're about to settle a case, use an online recapture tool. This is basically to prevent the IRS from thinking that you're overpaying in equitable division of property, but trying to call it tax-deductible alimony. So that's my overview of alimony. If you ever need help with any family law issue, please feel free to give us a call by Googling Collard Shopwood. Thank you.